And welcome back here to Live Now from Fox. We're heading out to Texas right now. The Texas abortion law, the U.S. Supreme Court reviewing the heartbeat bill, which as of tomorrow bans abortions after fetal heartbeat can be heard. That's usually around 6 weeks before most women realize they're even pregnant. And the law lets anyone sue anyone who helped a Texas mother obtain an abortion after that point. To dive a little bit deeper into this, I have on the line right now Jessica Levinson. She is usually coming on, our election law expert, but also following this case. Jessica, can you hear us?
I can. Hello.
Perfect. We have you too. Andrew Kraft is also here with me. We have some questions for you about this, and this is somewhat timely going into tonight. Can you break down kind of the history of this?
Yeah, absolutely. So Texas passed this very restrictive voting law, and it was immediately challenged. As you said, and I think it's so important that you mentioned this, this is not just about restricting abortions, but it would really upend a lot of our understanding of who can sue to enforce these rights. So it would allow any private individual to sue anybody who aids and abets a woman who tries to obtain access to an abortion after about 6 weeks of pregnancy. So it really has these two very important components, one about access to abortion and one about who can sue. And we can kind of spin out and imagine how there are so many ways where if states, both blue and red, start passing laws that allow any private individual to try and sue to enforce those laws, that could drastically change our understanding of, frankly, the legal landscape. But back to this particular law, there was a hearing scheduled Monday morning in the Fifth Circuit to try and determine what's going to happen to this law. Will it go into effect while there's litigation? Will it not go into effect? That hearing was canceled. Everything in the Fifth Circuit was canceled as a result of Ida. Now, this hearing was supposed to be in Austin, so it could have gone forward, but it didn't. The opponents of the law applied as an emergency matter up to the Supreme Court. They said this law is going to go into effect midnight September 1st, which, of course, is just in a matter of minutes. The reply brief came in just hours ago, and we have heard crickets thus far from the Supreme Court.
Jessica, Andrew Kraft here. You know, I'm curious as well, because I was a little confused. You know, why is the Supreme Court reviewing this? You kind of alluded to this because of Ida, and that's why all the hearings were canceled in the Fifth Circuit. Shouldn't the Fifth Circuit first decide? That's the mid-tier level, and then it will get up to the Supreme Court. Why is it going out of order here?
Great question. So a couple things. One, this isn't a ruling on the merits of the law. We haven't had a full trial on the law. This is about an emergency injunction saying don't go into effect SB 8, this Texas law, right now. And you're absolutely right. Typically what we would see is the district court would make a decision, then would go up to the Fifth Circuit. The Fifth Circuit was supposed to have oral arguments. They didn't. But there's no constitutional requirement that they have oral arguments, or in fact that they explicitly act on this request of an emergency stay. So we have seen this happen in other cases where, because the Fifth Circuit doesn't act, essentially the trial court's decision to say this law can go into effect is the last decision. And so we have seen in the past, it's very unusual, but then you can say, okay, well, that intermediate court, the Court of Appeals, they either, by making no decision, have made a decision, meaning by not doing anything, then this law will go into effect. So we're going to go straight to the Supreme Court. We've seen a proliferation of emergency appeals to the Supreme Court in the past. And I will say a lot of people absolutely on pins and needles. And think of how consequential this will be if the Supreme Court decides to let this law go into effect, even for a short period of time.
So, Jessica, pretty simple question for you right here. What are your expectations?
You know, my expectation is if the Supreme Court does follow current precedent, then what you would say is, okay, it is Roe versus Wade and Planned Parenthood versus Casey, that 1992 case that Dakota, you and I have talked about. Those are still the law of the land. you can't square this Texas law with those particular cases. And so at least for now, that Texas law is on hold. And then what I would expect is the court will hear that Mississippi law, that challenge to the Mississippi law that essentially bans abortion after 15 weeks, next term in a normal case, not an emergency appeal. I expect that this conservative court will uphold that Mississippi law. And then you will see other states saying, okay, now we can basically do things that are consistent with what Mississippi did. It would be really extraordinary if the court essentially allows this law that goes against Roe and goes against Casey to go into effect without saying anything at all or ever explicitly overruling those cases.
You know, Jessica, we have to mention, because this is historic, and not only the unprecedented aspect that, like you mentioned, could change the legal framework of this going forward, letting anyone sue anyone who helped someone in Texas obtain an abortion. That is unprecedented, but also the new court. I believe this is the first time they are hearing anything abortion related. Isn't that right, with the new conservative majority?
So they have heard abortion-related issues. They haven't heard something I think that we would consider to be as clearly creating a question of whether or not Roe can stand. So they did hear a whole woman's health case before, but this is the next kind of big challenge for the full court with Justice Amy Coney Barrett, who, as we remember, was confirmed in October on the court. And as I said, the court is scheduled to hear that challenge to the Mississippi law next term. And that's how these cases are supposed to go. This isn't supposed to all happen by emergency appeals. You're supposed to have a full briefing and then full oral argument.
You know, Jessica, I just want to kind of go on a tangent here for a moment because speaking of the makeup of the court, everyone's been talking about Stephen Breyer on if he'll retire soon so President Biden can appoint his replacement. He was asked in an interview about that, and he mentioned specifically the emergency applications. He thinks the Supreme Court takes too many of them. What do you think about that? That's really interesting insight into kind of the thought processes behind the justices and having to decide this.
Absolutely fascinating. And that interview, if we're thinking of the same interview, was also fascinating because Breyer is kind of known and, in fact, sometimes chastised for creating these really complicated, multi-pronged tests for big legal questions. And when he was asked would he retire, he basically answered in the form of a really complicated, multi-pronged test where he said, well, on the one hand, on the other hand, and I'm looking at all these factors. But Andrew, to get to your question, I think what he's pointing to is what we were just talking about, which is when the Supreme Court makes the decision, and this was actually to two of your questions. You said, basically where's the Fifth Circuit? That intermediate court is supposed to first weigh in. When cases come to the Supreme Court, they really should have already gone through the full trial process, the full Court of Appeals, and then we have a full appellate briefing again before the court. There's typical 90-minute arguments. And when the court is asked to decide matters like this, they don't have the benefit of all of the information. They don't have the benefit of all of the oral arguments, the amicus briefs. They have much less before them. But increasingly, they are making these incredibly consequential decisions based on, we've seen it now during the Biden administration. We saw it during the Trump administration. You have to stop, fill in the blank, the travel ban. You have to stop this particular law from going into effect. It used to be that these emergency appeals were really much more about, like, for instance, the death penalty. Will this person be put to death at midnight or not?
Very interesting.
Hey, so Jessica, we're going to put you on the spot right now because we always do that here on the show. Let's talk some of the other things that are going on in Texas right now. Following up on SB 1, it's hitting the governor's desk. It's going to change Texas election laws with bans to drive-thrus or 24-hour voting. But there are some expectations that it could get tied up in court battles. What are your expectations?
Yeah, so typically it's so hard for me to make a prediction. And, well, on the one hand, on the other hand, I'm pretty comfortable saying there will be litigation with respect to SB1. So as you said, SB1, a voting law that some people would say, tightens up problems with the voting system, ensures that there's no fraud, creates more security. Other people would say clearly a restrictive voting law that is just meant to make it harder for certain people to vote. You talked about, eliminating drive-through voting, new regulations for early voting, a ban on distributions of mail-in ballots, new voter ID requirements, all of these things that we've seen litigated in the past. But what we haven't seen in the past is that this is, as we were just talking about, this is a new court. It's a new conservative court. The court just, about 10 weeks ago now came out with a very, for some people, troubling decision dealing with voting rights, essentially making it a lot harder to make the case that you should be successful under a Section 2 voting rights claim. And so I'm comfortable saying that there will be suits. I do not think it's clear under our current framework of the Voting Rights Act or under our current Supreme Court that those suits will be successful. You could also have state court suits, but under the Texas Constitution and given the makeup of the Texas State Court, also not sure if those suits will be successful.
And of course, Jessica, that was a huge political story this summer as those Texas House Democrats came en masse to Washington, D.C. as a protest to not make quorum to vote on this. It's now passed both the House and the Senate. So we're just awaiting Governor Abbott's signature, and we'll see where it goes from there. We want to thank you for joining us here on Live Now from Fox. Jessica Levinson, electoral law expert.
Absolutely. Always a pleasure. Thank you.
And I'm sure we'll be speaking with her soon. We're going to take a 2-minute break here on Live Now from Fox. A busy